Today, we look at a story involving two miners, a bank, and an insurance company. Our story involves two men, Mr. John Mbita and Mr. John Chushi. Both were employees of Ndola Lime Company and both had personal loans with Barclays Bank. If you have a bank loan, you probably have credit life insurance. This is meant to pay off your loan if you pass away or become too sick to work. Their loan agreement included insurance. If they were medically discharged, meaning they were too sick to continue working, an insurance company called Aflife was supposed to pay the remaining balance of the loans. In 2009, both men were indeed medically discharged due to illness. They expected that since they were sick, the insurance would step in. However, instead of the insurance paying, their employer followed instructions from the bank and deducted the full outstanding loan amounts directly from the men's retirement savings, their terminal dues. Terminal dues mean the final lump sum of money paid to an employee when they leave a job. The men were left with much less money than they expected. They sued the bank and the employer to get their money back. The case went all the way to the Supreme Court. The judges looked at a document called the Master Policy, which contains the rules for the insurance. The court found that there were two very different results for the two men based on their actions. The case of Mr. John Chushi. The insurance company Aflife had started looking into Mr. Chushi's case. They asked him to undergo a medical examination by their own doctor to confirm his level of disability. This was a right the insurance company had under the contract. However, Mr. Chushi's lawyer sent a letter that halted the process, and he did not go for the extra tests. The Supreme Court ruled that because Mr. Chushi refused to follow a binding rule of the insurance contract, he lost his right to the benefit. The bank was allowed to keep the money they took from his savings. The case of Mr. John Mbita. For Mr. John Mbita, the situation was the opposite. The bank could not provide any evidence that they had even started the insurance claim process for him. They didn't show the court that they had filled in the required forms or submitted his documents to the insurance company. The court ruled that the bank neglected its duty to help Mr. Mbita get the insurance benefit. Because the bank failed to do its part of the paperwork, they were not allowed to keep the money they took from his terminal dues. The court ordered the bank to pay Mr. Mbita back his money with interest. What can we learn from this judgment? Number one, cooperation is mandatory. If you want insurance to pay your debts, you must follow their rules. If the insurance company asks for a medical checkup by their own doctor, you must comply. If you refuse, you might end up paying the debt out of your own pocket. Number two, the bank has a duty of care. When a bank signs you up for insurance, they have a legal responsibility to process the claim forms and paperwork correctly. Number three, the fine print matters. Most borrowers never see the master policy between the bank and the insurer, but this case shows that those rules are what the court uses to decide who is right. Always ask about the specific requirements for a claim to be successful. Thank you for watching Legal Stories. Remember to follow us on all our social media platforms.